Welcome to Live at Lunch. My name is Emily Sumner, and today we're talking about the employment-based aspect of Biden's announcement that came out last Tuesday. So last Tuesday, when we had this live stream, the announcement had actually just come out. It was brand new, fresh information. We did have some details about the aspect of the announcement that affects individuals who are married to US citizens. That information still applies, it's still true. But there was a second part of this announcement that referred to DACA recipients and, quote, other dreamers who may have the opportunity to have work authorization, or rather, they specifically said work visas, that they would be expedited or maybe expedited. It was kind of a cryptic, to be honest. The second part of that announcement was cryptic. I didn't quite understand what it was getting at, what it meant, but we now have more information. It is not the magic solution that we all hope that it is. You know, we would hope for a miracle, you know, for DACA recipients to just be able to work in the United States. So it's not a situation where President Biden is stapling an employment-based green card or even an employment-based visa or work authorization to a person's U.S. graduate or to a person's U.S. diploma if they've graduated with a bachelor's or a master's or whatever it is. That is not the situation. And it's not what I didn't expect that for sure. But like I said, now we have more information. So the situation is, right now, if a person has DACA, they probably also have work authorization, meaning they work. Let's say that a person has graduated from high school or from a, more importantly for this case, from a university, and they're able to work in the United States. That's great, but we don't know what the future of the DACA program is. It would be better. They would have a more secure path to be able to work longer term in the United States and eventually potentially to apply for permanent residence through their employment in the United States if they were able to change to a visa classification, a temporary visa classification. So we have a video series on YouTube, on our YouTube channel called Sumner School Business Immigration Basics, where we go through a number of these temporary visa classifications. For almost every letter of the alphabet, there's a different visa classification and then subclassifications within those. They all have different requirements, purposes, durations, things like that. So it's complicated. You have to find the specific visa classification that is appropriate for your particular situation. So for a DACA recipient to be able to get one of these work visas, employment visas that's mentioned in the Biden announcement, they still have to go through the same path that anybody else does. They still have to, of course, meet the requirements for that particular visa classification. They still have to apply. They still have to pay the fees. In addition, if there's a work visa, for example, a classification that has a numerical limit every year, such as the H-1B, for example, they still have to go through the lottery process, just like everybody else would have to go through that lottery process. The challenge with DACA recipients, depending on their particular situation, is if they have accrued unlawful presence in the United States, they cannot, depending on how they entered it, if they have unlawful presence in the United States, they cannot change their status. DACA is not really considered a status, but they can't change to a visa classification here in the United States. So let's say that John Doe has DACA and he, let's say that the employer registered him in the H-1B lottery and he was selected. That's fantastic, but John Doe cannot then apply for a change of status from DACA to H-1B because DACA is not considered a status. So what do? You might think, okay, why doesn't John just leave the United States, get an H-1B visa overseas, and then re-enter the United States? The answer is no, please do not leave the United States, because he could be subject to a 3 or 10-year bar to re-entering the United States. That is because if a person has accrued more than 180 days but less than a year, or 180 or more days or less than a year, and up to a year, or less than a year of unlawful presence in the United States, meaning they've been here without documentation, then a person is subject to a 3-year bar to re-entering the United States. If a person has a year or more of unlawful presence in the United States, they're subject to a 10-year bar to re-entering the United States. So those are only triggered if you leave the United States. So that's the problem with John Doe's situation, is even if he has DACA right now, if he did want to change to a more secure path that is likely to be available in the future, and we don't know, like I said, what's happening with DACA, it's been litigated a lot, then he can't change status in the United States and he can't leave the United States and apply for a visa because he would be subject to one of those bars. So what does this announcement say? This announcement says that DACA and other DACA recipients and other dreamers who are otherwise eligible for work visas, and there are a couple other requirements as well I want to mention. Those requirements are that they have earned a degree from a U.S. institution of higher education. That means that it has to meet the regulatory requirements. It has to be accredited, and it cannot be a for-profit institution. So if they have a degree from a U.S. institution of higher education, and if they have a job offer from a U.S. employer who in a field of study or field that's related to their field of study, then they are supposedly eligible. They are eligible for this second part of Biden's announcement. So that announcement is that they can apply for a waiver. This is not a new type of waiver. This waiver has existed for a long time. It is sometimes called a D3 waiver. That comes from the section of the law that outlines this particular waiver. The section of the law is the INA 212 D3. So I say that because you might have heard of that, a 212 D3 waiver. I'm saying 212 D like dog, 3 like 1, 2, 3. So that waiver has existed and it's used for all different purposes for non-immigrant visas, but it can be used to overcome, like I said, a number of different bases of inadmissibility, one of them being the unlawful presence. So in other words, it can potentially overcome that 3 or 10-year bar if a person is subject to it. So it's not a new waiver. It's not a new process. The process for applying for the waiver will be the same. The announcement is basically saying, hey, we are coordinating. We have directed the various agencies that are involved in this, which would be Department of Homeland Security, Department of State, CBP, to coordinate to potentially expedite the waiver. It's probably going to be discretionary, and to give further guidance to Department of State about how to process these waivers. So again, it still seems a little nebulous, not potentially as helpful as one would hope, but it is something. It is a step forward, potentially, for individuals that can take advantage of this. There is still going to be a risk with traveling. It's not guaranteed that these waivers are going to be approved. So you could go through the whole process of having the required non-immigrant petition approved. So let's say you could be registered in the lottery and have the H-1B approved, or you could have you could have an L petition approved, or you could have an E petition approved, although that's a little different. You apply at the consulate a lot of times. Anyway, you could have a petition approved, or go to the U.S. consulate and apply for one of a visa that you're qualified for. So for example, the TN visa, if you're a citizen of Mexico, you apply directly at the U.S. consulate in Mexico. You don't have to have an underlying petition approved. Anyway, my point is that once you leave the U.S., there's not a guarantee that that waiver will be approved and you'll be able to come back in. So there is still a level of risk. We're hoping that we'll get some additional clarification on that, the process, or guidance rather, for, like I said, they say the process is not going to change, but guidance from Department of State. As of yesterday, the information that we have available says that the updated guidance, and I'm looking at my notes here, that the updated guidance for consular officers, so that's the Department of State is the agency involved in that, will be issued within the next 30 days. This is the end of June, so hopefully by August 1st, we'll have that additional guidance for consular officers who may be processing these waivers. So again, this aspect of the work visas or the employment visas for DACA recipients and dreamers is not the magic solution that some might have hoped for, but it is a step forward. It is a way for individuals to potentially get on a more secure path than DACA is right now. Like I said, DACA has been litigated, as you probably know, over the years, and it is, if you have DACA right now, then you're okay, and you can, you likely have a work authorization tied to that, but we don't know what's going to happen with DACA in the future. So this would be a way for a foreign national who is a DACA recipient right now, or potentially other dreamer, to be able to get on a more secure path if they're able to have the petition approved if that's required, and then have this waiver approved, and then ultimately re-enter the US on the visa. So I hope that this information is helpful. Like I said, it's not, the exact news that we wanted, but it is a step forward. I hope you found this helpful. If so, I hope that you will drop your questions in the comments. I'm happy to take a look at those and answer as much as I can. The other aspect of the Biden announcement regarding the spouses of US citizens who have been married for at least 10 years, that is still in play. We're still waiting for those regulations. I really don't think we're going to have those regulations soon. The announcement that I'm referring to here did not reference a timeline for the regulations, but we do have to wait for the regulations for that aspect, the family-based aspect of the announcement, before you can start filing anything. So typically those regulations would come out within about 60 to 90 days. At one point, information from the White House said that they hope that people will be able to start filing before the end of the summer. So hopefully that's the case, but we'll keep everyone updated. Otherwise, I hope that you will share this video with somebody, drop your questions or comments in the comments section, and I'm happy to take a look and respond as I can. And otherwise, I hope you'll join us next Tuesday at noon. My name is Emily Sumner with Sumner Immigration Law. We serve clients throughout the United States and around the world with employment-based and family-based immigration matters. Until next time.